Hey everyone, so today's explainer is diving into something that honestly probably sounds like standard, boring administrative procedure. But as you're going to see in just a minute, it actually holds some pretty explosive legal and financial consequences. We're talking about the legal sanctity of HR records. And to really unpack this, we're going to look closely at a fascinating recent judgment out of the Karnataka High Court from July 2026. It involves a high-profile doctor, two rival hospitals, a forged signature claim, and a massive wake-up call for corporate governance. Okay, let's dive right into this. Here's a quick roadmap for today. We're starting with the inter-hospital dispute, then moving to the High Court's ruling and looking at a $70 million lesson. After that, we'll reframe HR docs as legal evidence, expose the governance deficit, and wrap up with some practical lessons for HR. All right, kicking things off with Section 1, the inter-hospital dispute. Basically how a routine background check somehow escalated into a criminal court case. So picture this. The inciting incident here centers around a highly respected oncologist. In 2022, after nearly 19 years of service at Manipal Hospital, he resigns to take a higher position at a rival institution, Astor Hospital. He was formally relieved, totally with appreciation. But about 3 months later, things take a sharp turn. Manipal Hospital gets an email from a background verification agency called Dataflow, and attached to this email was a copy of an experience certificate for the doctor bearing what looked like the signature of a Manipal official. Well, the hospital declared that signature to be forged, and they actually initiated criminal proceedings. Now watch how this spirals. The police investigate and they submit a B report, which essentially means they closed the case because they found literally no evidence of a crime. But Manipal wasn't satisfied. They protested, and the magistrate actually issued court summons to the doctor. So, facing an absolutely unwarranted criminal trial over a background check document, the doctor appealed to the High Court. Which brings us right to Section 2, the High Court's ruling and how they restored some judicial balance. So, in a pretty powerful July 2026 judgment, Honorable Justice M. Nagaprasanna firmly stepped in and just quashed the proceedings. The court called the continuation of this case an abuse of the process of law and a miscarriage of justice. And you gotta read this incredible quote from the court's oral advice during the hearing. Allow doctors to treat patients. Do not drag them into your inter-hospital disputes. It's just a brilliant, perfectly balanced stance. The court slammed the brakes on using criminal law as a weapon for corporate rivalry. But importantly, they also refused to permit retaliatory proceedings from the doctor for malicious prosecution. They just totally de-escalated the whole situation. Now, you might be wondering, why does this matter outside the medical fields? Well, let's look at Section 3, a $70 million lesson, and the Satyam you paid precedent. This right here is why it matters. Disputed signatures on mundane employment records have triggered massive corporate fallout before. $70 million. That's the sheer financial scale of the reported settlement from the infamous You Paid Satyam controversy that surfaced nearly 2 decades ago. Let's contrast these two cases for a second. In the Manipal Hospital case, the escalation was thankfully prevented over a simple background check. But the Satyam You Paid case? That spread like wildfire into massive patent litigation involving corporate giants like Qualcomm and Verizon over a $10 million software project. UPaid wanted to patent technology that Satyam had developed for them, so they needed the signatures of the developers on intellectual property assignment documents. The problem? By the time the patent suit happened, some of those former Satyam employees had moved on to work for Verizon and Qualcomm, and when asked, these former employees flat out denied that the signatures on those vital assignment documents were theirs. No way, they said. The lesson here is staggering, guys. A casually prepared document today can become the deciding factor in multi-million-dollar litigation years down the line. And that leads us perfectly into Section 4, HR docs as legal evidence and the new paradigm. You know, we usually treat things like experience certificates, relieving letters, employment verification responses, and promotion letters as totally mundane administrative paperwork, just something you file away. But under the Information Technology Act of 2000, every single one of these is a legally valid electronic record capable of becoming evidence in court. Furthermore, under the Digital Personal Data Protection Act of 2023, they are classified as personal data requiring strict governance and protection. They aren't just HR files anymore, they are legally binding electronic records. Which gets to the root cause of the problem in Section 5, the governance deficit and asking the right forensic questions. Because beyond just the criminal dispute, this entire situation exposes a massive gap in how organizations handle the authenticity of their digital records. Let's put on our detective hats for a minute. You have to ask, did an original signed experience certificate actually exist in the first place? Or was this document generated electronically purely for verification purposes? How did the background verification agency even get their hands on it? Or how about this? Here's another incredibly common scenario. Was the signature simply copy-pasted from another legitimate record by someone just trying to be helpful? Honestly, it happens all the time. An administrator is just trying to clear their inbox and quickly facilitate a background check, completely unaware of the severe legal consequences of replicating a signature. Or maybe a prospective employer specifically demanded a certain format. Innocent administrative shortcuts can rapidly turn into absolute legal nightmares. So how do we actually fix this? While the Data Governance and Protection Standard of India, or DGPSI, makes it crystal clear that HR documentation deserves the exact same rigorous standards we apply to financial records, organizations absolutely must implement strict controls. We're talking about governing the creation and authorization of records, using robust digital authentication mechanisms. We need version control and audit trails for every single modification. We need secure storage and transmission, and strictly formal procedures for exactly how we respond to background checks. I want to highlight this absolutely crucial takeaway from our source material. Listen to this. Many cyber incidents are not failures of technology. They are failures of governance. It hits the nail right on the head. Technology merely exposes the underlying administrative flaws. If your HR department is just emailing around scanned signatures, well, that's a governance failure just waiting to be exposed.
Let's wrap things up with Section 6, Practical Lessons for HR and Building a Trust Architecture.
So, here is your game plan based on Naavi's analysis of the case. First, as we've established, treat every HR document as a legally significant electronic record. Second, document your verification procedures. You need to know exactly who is allowed to issue responses and how their authenticity is preserved. Third, organizations need to progressively kill off the scanned signature. You've got to replace them with real digital signatures, secure verification portals, or verifiable electronic credentials. Fourth, cyber law training can no longer be limited to just your IT department. HR personnel, recruiters, and vendor managers handle electronic legal evidence every single day. They need the training too. And finally, mandate collaboration. Your data protection officers, chief information security officers, and HR heads have to work together on this. Governance begins long before litigation ever starts.
I want to leave you with this final provocative thought to summarize everything we've talked about today. Every HR document is also a cyber law document. Really think about that for a second. If questioned in a court of law tomorrow, could your organization prove the absolute authenticity, integrity, and provenance of the documents sitting in your HR files right now? Would your trust architecture hold up? Or would you find yourself in the middle of a corporate nightmare? It's definitely something you're going to want to review with your team. Thanks so much for joining me on this explainer, and keep learning.